Good evening and welcome to the 19th Amendment and our unfinished business. I'm Praveen Fernandes, Vice President at the Constitutional Accountability Center, otherwise known as CAC. We are a nonprofit, public interest, law firm, think tank, and action center dedicated to advancing the progressive promise of the Constitution. Almost 2 weeks ago, when we received the devastating news of Justice Ginsburg's passing, we momentarily thought of canceling this program. And then we thought, what better way to honor Justice Ginsburg's legacy than to have this conversation situated at the intersection of gender equality and voting rights, two areas for which Justice Ginsburg is rightly recognized as a champion. The 19th Amendment, which was adopted 100 years ago, prohibits the federal government and the states from denying or abridging the right to vote on account of sex. But unfortunately, this huge movement forward, which absolutely was a victory for both women and for our democracy's vitality, had promises that were illusory for a lot of women at the time of the amendment's adoption. More soberingly, a century later, many women still face a panoply of obstacles to exercising their right to vote across this nation. So tonight is about celebrating the 19th Amendment and its 100 years and what that did for our democracy. But it's also about acknowledging the work that is left to be done and the work that all of us have to be engaged in doing. We have a fantastic array of panelists this evening, and I look forward to introducing them in turn. But to start off, we have a keynote by Catherine Lhamon, Chair of the United States Commission on Civil Rights. We are so lucky to have Chair Lhamon with us. A full accounting of her bio would keep you from hearing from her this evening, so I'm going to be, in fact, very, very brief. Catherine serves as the chair of the U.S. Commission on Civil Rights, but she also serves as Legal Affairs Secretary in the cabinet of California Governor Gavin Newsom. Of course, some of you might also know her from her Obama administration days at the Department of Education, where she served as Assistant Secretary for Civil Rights. Perhaps you also know her from the National Center for Youth Law. Or perhaps you know her as I do from her days as a litigator at the ACLU of Southern California, where she used state constitutional law to challenge the brutal inequalities in school funding. Regardless of when and where you know Chair Lhamon, you will recognize the through line in her work. Her belief in the power of the law to address inequity and in the ability of the law to serve as a force for good. We're so lucky to have her with us this evening. Thank you. Chair Lhamon.
Thank you, Praveen, for that very kind introduction, and thank you so much to CAC for bringing us here today to commemorate the 19th Amendment. As we know, truly honoring the 19th Amendment means recognizing both the persisting power of its simple promise that the right to vote cannot be abridged on account of sex, and the gaps we have yet to fill to ensure that all citizens can exercise this right that is core to democracy. Too many of us view voting rights as an anachronistic abstraction and take for granted the degree to which we enjoy the right at all. The sad, scary reality is that the contest over the right to vote very much persists today and has been a distressing feature of American life consistently throughout the Republic. I want to be sure we are crystal clear about what voting contests are actually about. Race discrimination, sex discrimination, anti-poverty bias. Constricting the right to vote is about discrimination in its basest, its ugliest forms. When we talk about voting rights, we are not talking about the simple question whether someone did or did not exercise that right. We are talking about whether a person counts as a person for purposes of our democracy, and whether we value that person enough to participate fully with that person in the choices for how and whom to govern. Consistently, over time, some among us have purported to determine that others among us don't have the cognitive capacity to make sound choices about whom to elect and what their policies should be. That view is profoundly anti-democratic, as well as disrespectful of the personhood of disenfranchised persons. Specific to our conversation today about the 19th Amendment, the U.S. Commission on Civil Rights' recent investigation into the status of voting rights confirms ongoing voting discrimination with direct impacts on women. For example, changes in names due to marriages and divorces mean that women are disproportionately affected by onerous voter identification and documentary proof of citizenship requirements. This reality has real-world impact right now. The Commission unanimously found that dozens of states enacted newly restrictive voting rights laws in recent years, ranging from strict voter identification laws to imposing voter registration barriers, such as requiring documentary proof of citizenship, among other categories. Because of name changes, women may have increased difficulty in showing documentary proof of citizenship that matches current records. We have specific examples from some of the state advisory committees to the Commission and what they found in their investigations about voting rights. For example, the Kansas Advisory Committee to the Commission identified steep costs Kansans have had to pay to prove eligibility to vote. As an example, a woman paid $75 for a birth certificate from another state and then had to obtain her marriage and divorce decrees from still other states to complete her registration in the fourth state, Kansas, where she then lived. Our Kansas Advisory Committee also received testimony about the difficulty facing transgender people to obtain documentation that reflects their name and gender identity, and the process for changing these documents is complex and cost prohibitive. Similarly, our Arizona Advisory Committee heard testimony that women are less likely than men to have the required identification that complied with that state's voter ID requirement. Our Indiana Advisory Committee heard testimony that women who have suffered through domestic violence are at a higher likelihood of no longer living at their place of residence and therefore not getting information about ballot and poll access. The committee also reported testimony that single parents, who are most often women, reported an inability to find the time to maneuver bureaucratic requirements to obtain required documentation. And of course, the vast majority of these barriers I tell you about predated the pandemic we now live. The Commission received testimony about increased health risks associated with high volumes of people casting in-person ballots, with insufficient measures to guard against the transmission of COVID-19, against the backdrop of what we know about pronounced racial disparities in deaths due to coronavirus. The Commission received bipartisan calls for increased access to mail-in ballots, as well as substantial testimony about the need for safe, in-person voting options to preserve access for voters with disabilities and voters who require language assistance. I share all of this to underscore that at the very moment we celebrate the 19th Amendment, which deserves our celebration, we should also recommit ourselves to what it promises, that the right to vote may not be abridged on the basis of sex. And we should recommit ourselves to make that promise real for all women, including women of color, low-income women, transgender women, as well as to fiercely protecting the right to vote for every citizen. We have made strides in voter access since the founding of this country, strides that bring us closer to the true democracy that is essential to American ideals. And, as we know, the price of liberty is eternal vigilance. We must work for that future, and we must hold our political leaders accountable to ensure they do their part to make that future a reality. Thank you for coming together for this important conversation today and for your commitment to voting and to protecting voting. I leave you with the admonition that I, like many Black children, grew up hearing from my mother. People who came before us died for the right to vote. It's too consequential not to exercise it now. Please celebrate today and vote if you are able as soon as you can. Thank you.
Thank you so much, Chair Lhamon, for being with us this evening and for those inspiring remarks. You've certainly laid out a lot for us to think about, and I think our panel is very much the better for it. Thank you. Well, so we have a daunting task in front of us, and luckily, of course, it does not fall on my shoulders. We have two great panelists to continue this conversation, and I'm delighted to introduce them. Elizabeth Wydra, President of the Constitutional Accountability Center. You might also know Elizabeth from her frequent commentary on all of the law and policy issues of the day on countless media outlets. And we're so glad to also be joined by Jocelyn Frye, who is the Senior Fellow with the Women's Initiative at the Center for American Progress. And in keeping with the pattern for this evening, you might also know Jocelyn from her days at the White House, where Jocelyn served as the policy director for First Lady Michelle Obama. And I'm delighted that both Elizabeth and Jocelyn could be with us. Hello. Elizabeth, I think you're muted, so we'll address that. There we go first. And I would like to start with you, if that's okay.
Yes, absolutely.
Elizabeth, one of the phrases that is most tossed around at the Constitutional Accountability Center and throughout the work that we do is the arc of constitutional progress. Can you tell me what is the arc of constitutional progress and how the 19th Amendment fits into that?
Absolutely. So if you look at the Constitution, even at its founding, it was a remarkable step forward for democracy on the planet. It allowed for greater democracy than we'd seen in the modern era then, and it brought together the ideas of representation and equality and put forth this government that would have checks and balances. But of course, there were major, enormous flaws in this founding document. But one of the brilliant pieces of the founding document was that it allowed for amendments. And so we, the people, over time, made the Constitution to fit more within those founding ideals, which sadly were not completely manifest in the 18th century, but became more manifest as we, the people, over time, amended the Constitution to make it the document that we know and love today. We got rid of the original sin of chattel slavery with the 13th Amendment. We enshrined equal protection of the laws for all and equal citizenship and the right to life, liberty, and due process for all in the 14th Amendment, the right to vote free from race discrimination in the 15th Amendment, although that really only applied to men. Then, of course, what we're talking about today, the 19th Amendment, which ensured that the right to vote would not be denied on the basis of sex, and then increasing amendments that made our government more responsive to the people with the 17th Amendment, and more inclusive amendments to the Constitution, like getting rid of the poll tax, a very important amendment that ensured that you could not be denied the right to vote if you couldn't pay a tax or a fine or a fee in order to access the ballot box, and ensuring that young people who were serving in the military overseas, risking their lives for this country, could also vote. So changing the voting age to 18 and ensuring that the right to vote would not be denied on the basis of age. So through this arc of progress, you literally see the march toward equality, toward justice, written across the face of the Constitution.
Thanks for that description. And it's interesting because that description both tells us how constitutional progress has been made for a more inclusive and vibrant and strong democracy. But also, I guess, because you were mentioning many amendments, when you have something like the right to vote, how does the 19th Amendment function to either reinforce or entrench the right to vote? Because when you were sort of sketching that out, it seems like there are many amendments that reference the right to vote.
Absolutely. So there's no right that is more protected from discrimination than the right to vote in the Constitution. And again, we see that through prohibitions on discrimination on the basis of race, sex, ability to pay a poll tax, and age. The 19th Amendment, I think, is such an interesting part of this story of constitutional progress. If we look back at the movement for women's suffrage, this goes back to the very beginnings of our country. A lot of people think of the famous Abigail Adams quote reminding her husband to remember the ladies at the Constitutional Convention. Unfortunately, they did not remember the ladies. So it took movement of the people to finally get those votes written into the Constitution. The other thing that I think is incredibly important to remember about this movement is both the ways that it represented the intersectionality between gender equality and racial equality, and the ways in which it fell short of truly representing the interests of all women and all people in this country. There have been a lot of great pieces on this centennial celebrating the milestone that was the 19th Amendment, but also, I think, making clear the history, which frankly had been whitewashed. The idea that the only heroes of the women's rights movement that led to the 19th Amendment that we hear about are, Susan B. Anthony, Elizabeth Cady Stanton, when the fact is that there were incredible women of color who fought for the right to vote. People like Mary Church Terrell, Ida Bay Wells. The idea of Chinese American, Native American activists who really fought for the right to vote for women, but had been erased from that history. And so I think, fortunately, we're seeing a change with the history that is being, really promoted well, I think, during the centennial to bring those voices into their proper role as mothers of the 19th Amendment. Now, of course, like so much of our Constitution, this march for progress was often just a paper promise for far too many. We know that the right to vote free from racial discrimination promised in the 15th Amendment was not made a reality for all until, in a meaningful way, until we had passage of civil rights laws with the civil rights movement of the 20th century. And the same thing is true for the 19th Amendment. We certainly made an enormous first step toward equal citizenship for women with the 19th Amendment, but it also was an illusory promise for Black women, for Native American women, for Chinese American women who needed laws passed in order to ensure that they could enjoy their full rights to citizenship. So I think the 19th Amendment is a really good microcosm of all of the both good and bad that comes with our constitutional struggles toward a real country and document and reality that matches up with so many of the stated founding ideals.
Thank you. Actually, that answer was so good. It sort of envisioned and you predicted my next question, which is about some of the people who were left out of the promise, which you sort of very effectively addressed. I mean, I think one of the things that you had said is that the right to vote is referenced in more places in the Constitution than any other right that we have, and that of course the 19th Amendment is part of that reinforcement of that right. And you sort of sketched out some of the people who were left out of that. I'm going to ask you one more follow-up question on the sort of interaction between the Constitution and statutes. You brought up a very interesting point, right? Obviously about the Reconstruction amendments and the ways in which that promise extending the franchise to African-American, at that point men, because the 19th Amendment had not passed yet, wasn't actually been able to realize because of white supremacist violence against people who tried to exercise their right to vote. And so it took the Voting Rights Act. But you also mentioned, can you sort of talk about citizenship? We had the Chinese Exclusion Act, which prevented Chinese American women from being citizens, so they weren't able to exercise the right to vote. Would you like to say a little bit more maybe on Native Americans and other people whose citizenship was sort of in question and what prevented them actually from being able to exercise that right?
Yeah, absolutely. So I think, some of the ways in which the promise of the 19th Amendment was not a reality for women, particularly women of color in this country, was a result of, in some cases, statutes that prohibited certain categories of women from voting, like the Chinese Exclusion Act, that needed to be repealed in order to allow Chinese American women to vote. With Native American women, their citizenship was not recognized in the United States until legislation was enacted in the 1920s. And even then, there were some states that had laws that prevented Native Americans from voting. So those were statutory prohibitions, and then, often at the federal level. But then, of course, as we saw, unfortunately, in the wake of the granting of the right to vote free from racial discrimination for Black men with the 15th Amendment, the Jim Crow South certainly knew how to prohibit people from voting when they didn't want them to. And they certainly did when it came to women of color. And Mary Church Terrell wrote a letter to the head of the NAACP in one of those states saying, I am thrilled that we have the 19th Amendment, but we know all too well that the Jim Crow South knows how to prevent Black people from voting. And so there were both formal and informal ways of suppressing the votes of women of color, particularly Black women in the South. So we needed to have enforcement legislation passed at the federal level. We needed to have the Voting Rights Acts passed, the Voting Rights Act of 1965, which disallowed states from suppressing the votes of notably Black women and Native American women. And, we still see, as I know Jocelyn is going to talk about, barriers to women voting. And, it's a struggle that continues. The 19th Amendment was just a first start, and it was a great start. It was a necessary start, but it's something that we're still working toward. And when you think of the 19th Amendment as embodying not just the right to vote, but the right to equal citizenship, then we have a long way to go.
Thanks so much for that, Elizabeth. And actually, you've provided the perfect segue to loop Jocelyn into the conversation. And Jocelyn, I'll start with saying that a quick perusal of the press around the adoption of the 19th Amendment shows all sorts of parades of horrible situations that were sketched out. The nation will lose its ability to go to war. This will cause all manner of family strife as women have different political opinions from the head of the household, which of course was assumed to be the men in those households, either their fathers if they were not married or their spouses if they were married. And, so obviously none of those things came to pass. On the other hand, I think most historians and political theorists will look at the 19th Amendment and say there were actually profound effects that came from this step in expanding the franchise, just as there were during the Reconstruction amendments when African-American men first started to vote. So my question to you is, placing aside the apocryphal scenarios, what were the effects of the 19th Amendment, both on who was elected to office and the kinds of legislation and policy that had a new energy and valence?
Well, thanks, Praveen. I will pick up, I think, where Elizabeth left off, because you're right. There were these sort of drastic, I love your word, apocryphal predictions about what it would mean if women receive the right to vote. And clearly those sorts of developments didn't happen. But, it mattered that this was the single largest expansion of the voting franchise in history. An estimated 26 to 30 million women, at least theoretically, receiving the franchise. And what you did see is that there was some change in who was elected, although I will say not as much as you might have anticipated. People do take note of the fact that, even 50 years after the the passage of the amendment. If you looked at our Congress, there were very few women in the Senate or the House, and even today, with the largest number of women in the House in history, it's still just about a quarter. So I think the notion that somehow this was going to fundamentally change who was elected didn't really materialize. It began to change. You certainly saw more women engaged in the political arena and running for office, but it certainly has taken more time than perhaps people anticipated for those changes to really take hold. The other place that you saw change is in the types of issues that were receiving attention. There's certainly research that shows that you saw more investment in social spending. There's some research that suggests that you saw a decline in things like child mortality, increase in public health spending, increase in educational spending. And a lot of that is attributed simply to women's engagement in the political process and people running for office having to be responsive to these newly created voters who were suddenly people who could actually help drive change. So the change was important, significant, but I think also gradual, to be honest, in terms of the type of changes, in terms of who was elected and the types of issues that policymakers had to pay attention to.
Thank you so much for that. I'm going to have to plug at this point CAP's great report, of course, and that was published in August on the actual month of the sort of 100th anniversary of the adoption of the 19th Amendment, the ratification. And so, it brings me to the second question, which Chair Lhamon sort of teed up for us a little bit about actual practical problems that women who, are often looked at as a voting bloc, but obviously women have multiple identities, and there are particular women, not only women of color, but also transgender women, women with disabilities, who face particular obstacles in exercising the right to vote. I know your report went into that. Can you talk a little bit about how the obstacles to exercising the right to vote sort of play out in women's lives?
Absolutely, because that's so critical, and thank you for acknowledging the report that we published. Because I think that if you look at voting through the lens of the diverse range of women in our country, you really see firsthand the limitations of having the right to vote if there aren't sort of accommodations that acknowledge the lives that people live. And Chair Lhamon did speak about one of the particular issues that many women encounter is voter ID laws that require people to have an ID. There are women who don't have IDs for a variety of reasons. Older women who may not have the same documentation. They may no longer have documents in their maiden names. So they have limitations in terms of the documentation they can provide. Issues women, are frequently changing their names if they get married, and so they have limitations in having the types of documents that people may want to see. Transgender women, as you pointed out, may not be able to get the documentation that reflects their gender identity. So there are all sorts of limitations that are related to these voter ID laws. There are also limitations related to just the ability to access a voting place. Not every voting facility has a public access. This is particularly impactful for women with disabilities. There are states that have cut back on things like early voting. That's particularly important for women who disproportionately are in low-wage jobs. They may not have the flexibility to leave work and go to vote. so there are those sorts of practical limitations that they can't access the voting place on the weekend. They may not be able to vote at all. All of those things are barriers that confront women in particular in terms of just being able to access their ability to vote. And the other thing I would add to it is that the current moment of coronavirus only adds to that. Women are disproportionately essential workers. They are in jobs that require them to go to a particular place of work. They often don't have flexibility to leave. And so now in this particular moment, some of those folks are even struggling even more to find time to do things like voting. And those who are at home, many of them now are virtual teachers. They're managing a virtual classroom with children. Again, that limits their ability to go vote during sort of normal hours. And so all of those things are impacting on the ability of women to exercise the right to vote.
Well, thank you for that. And sort of really quickly, I think you sort of touched on this, but given those problems that you've articulated and that the report discusses, the Constitution, of course, is a floor, not a ceiling for protections. Were there specific policy prescriptions that you had, either dealing with the issue of leave, et cetera? What were those specific policy recommendations that you had, either on the federal or state level, for folks to consider to make exercising the right to vote a reality in the lived lives of women across the nation?
Yeah, thank you so much for that question, because there are certainly things that we could do at the national level, at the federal level, and at the local level. We shouldn't have to fight to go vote. It's a civic obligation, and we should be making it easier, not harder, for people to exercise that right. So there certainly are things like eliminating voter ID requirements. Those sorts of measures just are more harmful and really work to exclude people rather than include people. Things like it's more access to early voting, just to enable folks to access voting booth at a time that is convenient. Things like same-day registration that just allows people to be able to vote when they're available. Eliminating in some states now, there are measures that limit the ability of younger voters to vote. Sort of eliminating some of those restrictions are important. All of those are measures that we should be thinking about. But there are also broader issues around election security. I mean, there isn't anybody who hasn't heard about where we are at this moment in terms of mail-in ballots and just concerns about the integrity of our election. There are legislative measures that would put more money into election security, more money for polls, to support the polls and the integrity of the polls, more money just to ensure that people have the equipment that they need to make sure that the voting is sound and safe and electronically secure. These are all no-brainers, quite frankly. We shouldn't be arguing about these things. We all have a collective interest in making sure that we can vote. We can do so securely and fairly and without fear or of intimidation. So those are things we can push at the national level. There certainly is pending legislation, H.R. 1, H.R. 4, that would put resources into strengthening our electoral activities, but these are also things that states can address at the local level.
Thank you so much, Jocelyn. And I think we'll sort of loop together Elizabeth now for sort of like a little bit more of sort of a back and forth conversation. That was so helpful from both of you. And now I have the good fortune of having both of you on the screen to sort of talk to you at the same time. Jocelyn, you had mentioned sort of the growing political clout of women. And I will just say that for at least 2 Democratic presidents, the first piece of legislation that they signed were, pieces of legislation that were really pushed by women's groups. And so whether it was the Family Medical Leave Act, which of course was the national partnership where Jocelyn worked for many years, or the Lilly Ledbetter Fair Pay Act. Those were the first pieces of legislation. And anyone who knows sort of federal politics knows that the first piece of legislation that a president signs has incredible symbolic sort of, purpose. And both of those were pieces of legislation that were pushed by women's advocates, both in the legal and policy sector. So I would be remiss if I had not mentioned that. But it brings us perfectly to Justice Ginsburg, because, of course, she wrote the fiery dissent in the Ledbetter decision that led to the congressional fix. But a lot of people know about Justice Ginsburg's role, a trailblazing role in the sex equality struggle, but not as many people know about her role in voting rights. Would either of you like to take, sort of her role in sort of voting rights jurisprudence?
Well, I'll just, point out that, it's, in fact, I think her dissent from the Shelby County decision, in which the Roberts Court gutted the perhaps crown jewel of the Civil Rights Act, the Voting Rights Act, and its preclearance provisions. Her dissent from the court doing that is what I think led to the Tumblr, if I'm not wrong, that that kind of started the meme popularity of Notorious RBG. It's a testament to her writing to the people that a voting rights case dissent led to her becoming this kind of pop culture icon, because she cuts right to the heart of it in that case. The idea that, you have this voting rights law that has worked relatively well to prevent voter suppression, particularly targeted at African American voters and other communities of color, and also language minorities and other protected groups. This preclearance formula, which required jurisdictions with a history of discrimination to get basically approval to make voting changes, the idea that that was no longer necessary is just preposterous. And she wrote that in a way that was both legally sound and also spoke to the people who knew that idea that somehow we were past discrimination in this country was unfortunately not true. And so, I think in that sense, Justice Ginsburg's pop culture icon role is inextricably linked to her voting rights championship.
I completely agree with that. The other thing I would say that I think is so important about her legacy is that she understood discrimination. And she understood how discrimination was really embedded in the history of our country. And, much of her work before she got to the court was about undoing that and sort of deconstructing, eliminating those barriers, really doing, in many ways, the systemic structural change that we talk about now in the context of structural racism. So I think, when I look at that decision, Shelby County in particular, I think one of the things that, agitated her the most is that she understood the difference between discrimination that was designed to deny rights to people and affirmative efforts that were designed to correct a status quo that was inherently biased, right? And so, and I think to create this narrative, whether you're talking about voting or you're talking about education and desegregation or you're talking about women's rights, to create this narrative that the status quo is okay, she knew to be wrong, right? And so that's what I think is particularly useful about us reflecting on our history today, is because she understood the need for structures to change and that we had to affirmatively attack it and put measures in place to ensure that the status quo was corrected and we were doing things to actually make the promise of equality real for people.
Yeah, and Praveen, if I could just give a hearty amen to everything that Jocelyn just said. And, this isn't about voting rights specifically, but, to the extent that the 19th Amendment is about equal citizenship for women, Justice Ginsburg, her work, as Jocelyn referenced, as a civil rights lawyer before she was on the bench, and then her opinions on the bench, are really all about that promise of equal citizenship stature and the idea that gender constructs and gender discrimination should not prevent people from being able to live their lives fully as equal citizens in this country. And she fought against those barriers on behalf of male plaintiffs and female plaintiffs, with the entire idea of striking down the systems that prevented people from being equal citizens, regardless of their gender. And, that is a fuller concept of the equal citizenship presented in the 19th Amendment, but it's one which Justice Ginsburg, I think, uniquely championed on the bench, whether it was with respect to voting rights, employment anti-discrimination protections, to reproductive freedom. How can you be a truly equal citizen as a woman if you cannot control your own destiny when it comes to your reproductive capacity, your ability to go into the workplace and be treated fairly, the ability to cast your ballot on equal terms? It's all about the concept of equal citizenship stature, which she, I think, articulated better than anyone else ever on the Supreme Court.
Mm-hmm.
I can't believe that you thought that I would interrupt that. Amen. No, of course. Thank you for adding that. And I realize I should tee this up because we're sort of getting to the last 20 minutes, and I want to make sure that other people get to ask questions of both of you. So for members of the audience, I'm going to look down to make sure I don't mess this up. If you're watching via CAC's Facebook or YouTube channel, you have to be logged in to submit a question, but please send us your questions. If you're watching this through the CAC website, then you are actually watching via YouTube. So just expand your browser, log in, and submit your question. And Elizabeth, your question sort of brings me to a quote. Your comment brings me to a quote, because my next question was going to actually be about this equal citizenship stature part of Justice Ginsburg's work. Earlier this year, Justice Ginsburg was in conversation with Ninth Circuit Judge Margaret McCune at Georgetown at an event actually on the 19th Amendment in sort of the 9-month run-up to sort of, what people were going to celebrate in the fall. And she actually says exactly what you were saying, Elizabeth. She said, and I'm quoting here, "It was the first step towards equal citizenship stature for women. Some of the suffragists had high hopes for the 19th Amendment. Strictly, it said the right to vote shall not be denied or abridged on account of sex. But if women were to have equality in the political domain, that is, if they were part of the political constituency and could vote, then how could you abide subordination of women in the civil domain?" So she clearly saw the ripple effects from the 19th Amendment in this equal stature conversation about women in every sphere of life, the civil domain, the legal domain, the political domain. And this brings me to another observation that they had later, which is that she talked about the frustration of the 19th Amendment's language not being given full force, and the frustration of the sort of equal protection language of the 14th Amendment not being given full force. And that leading to some of the frustration and the motivation for the conversations around the Equal Rights Amendment. And my question to both of you about these sort of decisions is like, where are the places where you feel the courts have most profoundly stumbled in giving full force to either the equal protection language or the 19th Amendment promises?
Well, I'll start. Your question about most profoundly stumbled is an interesting one, because the truth of the matter is that there has been progress, but yet there's a lot of work to do. And I would start by saying that one dynamic that we can't get around is that, notwithstanding the words that are written on the paper of the laws that we pass, or the regulations that get written, it is that human beings still implement them and human beings still interpret them. And so as a result, what may have looked clear on paper, often doesn't work out that way. That is true across many issues. It is true, for example, around equal pay. The Equal Pay Act has been interpreted very narrowly. And as a result, there are times when, unless the jobs are exactly the same, people say, well, they're not equal. And so you can't pursue the case. There are limitations in terms of how the Constitution evaluates gender discrimination. Justice Ginsburg spoke about this a lot. It is given a lower level of scrutiny than racial classifications, slightly lower, but that's certainly not where she started. But that is how the law has been interpreted. There are certainly people that would point to the jurisprudence around reproductive rights, and the court has, narrowed sort of a full reading of the equal protection, how the Equal Protection Clause and how privacy protections actually ensure that women have access to abortion and the full range of reproductive access. So those are just a few. But the truth of the matter is that it's, whether you look at the courts or you look at agencies and how they interpret it, we still operate in an environment where the status quo is still always trying to preserve a status quo that can disadvantage women, notwithstanding what we think what laws we are passing. So that's just, work that we need to do to ensure that the laws we write, the principles that we say that we adhere to, actually result in concrete change for women.
Yeah, so I think that everything Jocelyn just mentioned is exactly right. And, I would add to that the idea that the Supreme Court has profoundly stumbled when it comes to voting rights generally. And of course, that impacts women profoundly. The Supreme Court has, both through affirmatively bad decisions, harmed voting rights. And I'm thinking specifically about the terrible Shelby County decision gutting the Voting Rights Act, which has allowed blatantly discriminatory voting rights changes to go into effect in the states. The Fourth Circuit, talked about some of the rules in North Carolina as being targeted with surgical precision toward Black voters. These laws have been able to go into place since 2016 because of that Shelby County decision by the Roberts Court. So that's an affirmatively bad decision from the court. And then there are other cases involving voting where the court simply refuses to step in and do its job of protecting the right to vote. And it's done that through principles of, claiming to want to avoid getting into political disputes. If it's in an election year, they don't want to get into striking down voting laws that might be discriminatory under the Purcell principle, which my colleague David Gans has written very eloquently about, or in the gerrymandering cases, not wanting to get involved. And, sometimes it is appropriate for the court to exercise restraint, but at other times the court needs to do its job to protect the right to vote. So I think voting rights has been a huge stumble for the Roberts Court. And obviously, a lot of people are thinking about that right now with the vacant seat, with the passing of Justice Ruth Bader Ginsburg and the potential of a confirmation of a nominee that President Trump said in the debate that he wanted to be on there so she could also look at the ballots. And so, voting is very much on the minds of the people when it comes to the Supreme Court, and of course, when it comes to their daily lives. But I want to get back to something you said, Praveen, when you quoted Justice Ginsburg talking about how the threat of equality in the 19th Amendment was a real, I say a threat because it was a threat to white supremacist patriarchal principles. And she's absolutely right. The beginnings of political equality would mean meaningful, broader equality for women. And you only have to look at the opposition to know that that's true. You know, the idea that women might be empowered to be truly equal citizens in society, in the workplace, when it comes to child care responsibilities, when it comes to economic success, was a threat to the status quo. The empowerment of Black women was a threat to the status quo. And the efforts to squelch that promise of equality, resulted in virulent suppression afterward. And, I think that as Jocelyn's earlier comments about everything we need to do to ensure that women actually enjoy equal citizenship show, this fight is still going on. We're not celebrating the 19th Amendment, yay, the work is done, hooray, equality is here. We're in that fight.
And can I add, Praveen? I'm sorry. I'm sure I'm violating a rule, but because I agree so much with what Elizabeth just said, and I just want to add one piece of it, which is something she said in her opening remarks, because I think the other thing we have to remember, and this was true for Justice Ginsburg as well, is that we can't always assume that the people who are perpetuating sort of ongoing discrimination and barriers to access are simply men, or sort of a prototype of a certain type of person, right? The advocates for the 19th Amendment and women's equality also were participants in preserving a piece of the status quo that denied access to that vote for other people who shared their gender. So we have to acknowledge that as we think about what are the things that we need to do to change, what are the things that we need to do to actually accomplish sort of equal citizenship, that people sit in different spaces, and we collectively have that responsibility, and it is not just about members of Congress or people in the administration. It is also about what we do in our own communities, in our own workplaces. Those are also places where people have the ability to drive change.
Absolutely. So the only reason you saw my eyes flicker is because I saw you got a spate of questions coming in. So I'm going to give you two, and maybe I'll ask them both at the same time, just because I know that time is running short. So great question. One says, would it be possible to challenge some of the voter suppression laws on the grounds that they violate the 19th Amendment, which of course prohibits abridging as well as denying the right to vote on account of sex? And so that's the first question. Second question is about women who have prior records, so prior felony convictions, in the progressive parlance, returning citizens, people who've come from serving a stint, in the incarceral system. How can the 19th Amendment be sort of applied and promised? What more needs to be done for them? Two questions.
I mean, I'll start. I mean, they're both great questions. I would say on the 19th Amendment argument, just to challenge voter ID laws, it's interesting. I certainly know that there are a number of cases that people have brought where the gender component and the fact that these laws have a disproportionate effect on women have definitely been part of the argument. I don't know whether they have invoked the 19th Amendment as part of that litigation. But I do know that the gender discrimination angle has been a key in some of those cases to really sort of talk about the reach and breadth of those laws and to talk about the impacts that people don't always anticipate. So I think it's an interesting idea and something that I think merits some close scrutiny. I don't know if that angle has been used, but I definitely support the idea. And then I remind me of the second question, Praveen. I'm sorry.
Sure. The second was actually about women who've had records of felony convictions and sort of turning citizens and making sure that the franchise was available to them.
The only thing I'll say, and then Elizabeth, please weigh in. I couldn't agree more that the issue around disenfranchisement of returning citizens is an enormous issue. I think that we should be investing enormously in removing those barriers, and we should be engaging in states like Florida, where they have erected sort of the 2020 version of Jim Crow to deny those folks their ability to exercise the right to vote. I believe, and I don't know every piece of that litigation, but I do think that there was some effort to raise sort of the gender equality piece of this in that case, because obviously there are effects on women that matter. I don't know if the 19th Amendment was invoked per se, but I do believe that they certainly tried to raise the gender, the impact on women in that conversation. And I agree that we ought to be focused on that. That ought to be a huge priority.
Yeah, I completely agree with that. And if you look at the constitutional protection of the right to vote, so much of it is intersectional. The idea that the 24th Amendment's protections against excluding people who can't pay a poll tax, and of course, some of the post-conviction fines and fees are just the modern day version of a poll tax. That's intersectional. You look at the 26th Amendment, which has been used in recent litigation that suppresses the vote of young people, students. That, of course, is intersectional as well. And so, all of these fights are really intertwined. And, I think that when you look at the attempts to suppress the vote, a lot of times the question is why? Why is the power of the people trying to be suppressed? And we have worked very hard to write these protections into the Constitution. And, empowering the people can be a threat to the status quo. And a lot of us think that that is great because it allows for greater progress. But democracy, is something that we have since the founding been fighting to make our democracy, make it more inclusive and make it more real so that people can truly have their voices heard, whether or not they're gajillionaires and can give a lot of money, whether or not they themselves have walked in the halls of power. And, I think when you look at the right for women to vote and so many of the things that Jocelyn talked about when she talked about the challenges that women face, making ends meet, ensuring that their families are covered and can go to the doctor, ensuring that the water that their families drink is clean, the air that they breathe is clean. These are concerns at the heart of the citizenry. And so women voters' voices are more important than ever before. And, we have to fight back against efforts to suppress our votes and our voices.
If democracy is only as strong as its inputs, then the 19th Amendment, of course, enriched one source incrementally of inputs into this system. And the work ahead of us is to make sure that that continues, to make sure that those voices are continue to sort of broaden and become more inclusive, to make our democracy vibrant and healthy. And the worst part of my job is closing conversations, because quite frankly, I could happily listen to both of you for at least another 4 or 5 hours. But with that, I'm going to tip it off to Elizabeth to bring us to a close.
Thank you so much, Praveen. Thank you for moderating this discussion. Jocelyn, it was so wonderful to have you with us tonight. Thank you so much for all of your work that you do now and that you've done. We are greatly appreciative. Thank you to Chair Lhamon for opening us off with her really powerful remarks. And thank you at home for those of you who have joined us. And we just really hope that everyone gets out there and votes, make your voices heard, and vindicate the promises of the Constitution and the right to vote. You can check out more of the constitutional accountability at theusconstitution.org. We encourage you to stick with us and join us later for when we talk more about the progressive promise of the Constitution. Thank you so much to everyone who participated tonight.